Good afternoon, everybody. Thank you all for joining us. I'll begin the intro. Thank you for everyone's patience for letting everybody get signed up. We've got a great crowd today. My name is Mark Hefner. I'm the landowner advisor for Braun and Gresham and Plateau Land and Wildlife Management. I'll be the moderator. Joanne and I'll be working back and forth. Joanne's going to be the star of the show, but I'll be helping manage some of the questions. One of the things that's unique is owning rural land in Texas can be complex and have a wide range of issues. My role as a landowner advisor is to understand those issues and goals and help you work through them. Braun and Gresham is a law firm that is very unique in how they represent landowners and the wide variety of issues they face. So that's part of what we're bringing to the table today. Our sister company is Plateau Land and Wildlife Management. They work with landowners that want to transition to wildlife management as their valuation, but they also work with traditional ag landowners as well and have a team of expert biologists to help you. Today, I'd like to introduce Joanne Hatton. She's an attorney and counselor and will be giving the presentation. Joanne and I have been working together helping landowners for quite some time. And that's the genius of Braun and Gresham, is they hire people like Joanne that know this part of the world. We're going to be doing things a little bit unique on a Zoom call. In this situation, we're actually going to be able to communicate directly with you guys. You can unmute yourself, which you will have to do personally. You'll have to go down, find your little speaker, kind of usually at the bottom left, and unclick that and make it, take the red line away. If you would like to communicate directly, feel free to jump in. You can also submit your questions via the Q&A button. So feel free to type questions. I'll be helping, again, keep that organized. Either way, if you're comfortable doing that. If you're not, and you have something that's confidential or would like to speak to Joanne or one of the other attorneys directly, feel free to hold back. We're gonna give you our contact information. You can reach out to us directly as well. So again, don't hesitate to reach out. Joanne's prepared to answer, pause, stop, answer questions throughout the presentation. Lastly, we're going to be recording this. We're going to be recording this presentation. So again, if you're not comfortable, sorry about the phone. If you're not comfortable with saying your questions or asking your questions online, hold them and then we'll reach out to you, or you can reach out to us directly. Let's see, I think that was all. Yeah. So without further ado, I'd like to hand it over to Joanne Hatton and let her get started. Joanne?
Hi, thanks, Mark. Thanks for the introduction. And we're going to be talking a little bit about things you should know when buying rural property. And I'm going to share my screen here so you can all see a PowerPoint presentation. And I think that should do it. Mark, can you see that well? Is that properly up there?
I believe so. It looks like the full screen.
All right, great. And so some of the things that we're going to talk about today are what you might want to know before you purchase rural property. And one of the first things you want to figure out is how you intend to use the property. Are you going to use it for personal recreation with your family? Are you going to live on the land? Do you want to develop it either in a small way or on a larger scale? Do you want to divide this up among family members or create a rural subdivision? The next thing that you want to know is that you want to purchase title insurance. And we'll talk a little bit about that. We'll talk about how important it is to carefully review a title commitment and what that means. You'll want to know the options for developing the property, whether that means building a house on it, a cabin, building many homes on it, or just building a few homes for your family members, or any other kind of development that you might be interested in pursuing on that property, whether it's big or small. You'll want to find out if there's an ag valuation on the property And you'll want to know how to either maintain or preserve that, maintain or obtain an agricultural valuation. And finally, we'll talk a little bit about how to protect yourself from liability, steps you can take to protect yourself from liabilities that might arise outside of the use of the property, or liabilities that might arise from the use of your rural property. So on this the first topic we're going to cover is how you plan to use the property. And, as I just said, will you use it as your residence or for recreation or development purposes? And by recreation, I mean those kinds of things. Are you going to be riding four-wheelers on it? Do you have plans to have a hunting lease on it and allow people to hunt on it? Are you going to hunt on it yourself? The next question you'll want to consider before you purchase is, do you want to hold that property in your individual name or through an entity? And a lot of times holding property in our individual names is okay. And that works out for a lot of people. But for other people, there are reasons to hold the property in an entity, especially if there are going to be activities taking place on the land, or you're going to be renting the land, or having the public be using your property. And holding property inside of an entity such as an LLC can give you kind of a shield to protect your other assets from liability if in the event you were sued. And then homestead protections, we'll talk a little bit more about that later. But for a lot of people, the homestead protection you have in Texas and insurance may be enough to protect you from most of the liability that you might encounter. And the other item you might want to consider when deciding whether or not to hold property in your individual name or in the name of an entity is if you plan to later develop that property more than a year from now. In certain cases, there are very large tax benefits that can be obtained depending on how that property was held prior to development, and steps we can take to help you to minimize your tax liability in the future if you do decide to develop the property in a way beyond personal use. And the agricultural valuation, again, whether what's going on the property, is there an agricultural valuation? Are there cows on the property now? Is there a wildlife valuation on the property? And finally, considerations regarding use. What kind of county regulations are there that might limit what you can do with the property? Are there any deed restrictions? Is the property located in a city or an ETJ? An ETJ is the extraterritorial jurisdiction of a municipality. And even if you're outside of a city, a lot of the time, the city does have some say over what you can do and how you can develop the property if you're within that extraterritorial boundary. And finally, water. You want to know what the water source is on the property. Are you going to need to dig a well? How deep are you going to need to dig that well? And are there limitations on how much water you can pull, or how big those lots need to be in order for you to put a well in that particular area? And so all of those things are things you want to check on in the time period before you put in an offer or during your option period. These are things you want to kind of have a general look into before you finalize your purchase of a rural property. The next item I want to talk about is title insurance. And I see a lot of transactions happen between rural landowners that haven't included title insurance. And title insurance is very important. Title insurance, you're spending, when you buy a piece of property, especially a large piece of property, that is a big purchase for most people. And title insurance helps to make sure and ensure that you have received what you thought you were going to get.
Hey, Joanne,
Mhm.
it's Mark. We had a question pop up. It
Sure,
was from the first section, I
sure,
believe, is where their question came from. Can you pause right here and answer this one, maybe?
sure. What can I do
It
for you?
says, I've seen some properties for sale. They have seller imposed restrictions. Do you know what those are and how are they enforced?
Yes. So I do help sellers impose restrictions on property they're selling too. So if you are selling a piece of property, and I'll talk about this a little bit from the seller's perspective, I think it'll give you a better idea of what the um, the the situation is with restrictions. Um, if a landowner wants to sell a piece of their property, say they have 100 acres and they're going to sell off 25, a lot of times at closing, what we can do if the seller wants to make sure there's not going to be a quarry next door, which happens, in some rural areas, or that there won't be some huge commercial development next to where the seller is going to be living. The seller can impose restrictions, and sometimes we do that with a restrictive covenant agreement at closing. And sometimes the seller will impose restrictions through covenants, conditions, and restrictions imposed on a larger piece of property or a number of lots or parcels. And those restrictions are usually about land use, and they are enforced by if the seller still owns a piece of adjacent property, they can be enforced by the seller. And so there are some limitations as to what a seller can restrict a buyer from doing, but those restrictions are enforceable as long as the seller still has, there are some nuances in the law, but as long as the seller still has a right to enforce those, which usually means the seller still owns a piece of property either within the lots that have been sold and subdivided, or an adjacent parcel where there was a restrictive covenant agreement as to the use of the land. As long as the seller still has power to enforce those restrictions, they can enforce them, and they can enforce them through the courts. So those restrictions usually cover, they may cover things like the size of a home. Sometimes people who've invested a lot of money in their property don't want to, or with larger homes, they don't want, sometimes they don't want somebody to put a trailer next door for hunting, or they don't want them to have an industrial use or a quarry. And so those are the types of restrictions that we see. Does that answer the
I
question?
think I think that does, Joanne. I'll ask the attendee if we didn't quite get there, please feel free to send us something else, and we can also take this offline if we've got some really in-depth question to answer. So thank you, Joanne.
Sure. And I will say this, I'd like to add that there are some restrictions and there are some ways that those kinds of restrictions can be removed in certain situations by owners of the properties. And sometimes those are negotiated, and sometimes it's just a matter of those people who are affected by the restrictions agreeing in writing to terminate those restrictions if the original seller no longer has any interest in the property, or adjacent property. All right, and let's get back to title insurance. And title insurance is it's insurance that makes sure that you're getting what you think you're getting. Title insurance is very similar to other types of insurance that you might have. When you think about insurance that covers your home or your car, as far as your home, as far as catastrophe or damages, title insurance, make sure that what you've purchased, you really got. And I see a lot of people who own rural property who've bought pieces of it or bought from their neighbors who did not have title insurance. And sometimes what they think they received is not what they purchased. Sometimes the person who sold to them only owned a partial interest in that property, and there is someone else who owns more of that, an undivided interest in that parcel. Sometimes people think they have a fee simple interest in land, and what they really have is a unit in a condominium. Sometimes people think that their title is clear and they own a piece of property, and there might be a right of first refusal that was supposed to be executed, and or a notification of a right of first refusal, which means someone else had a right to put in an offer or match an offer before it was sold. And so all of these things can be problematic to a buyer if they do not have title insurance. And I'd like to explain it this way. And it's especially important when people don't have a lender. There are two types of title policies. Generally, one covers the owner, the new owner, the purchaser, and one covers the lender. And the largest restrictions, the biggest restrictions, are usually the same on both of those policies. And so when there's a lender, the lender a lot of times will look out for those things, but it's important to have someone reading the owner's title policy to make sure that you are protected. And it's especially important if there is no lender. I have seen title policies that don't cover what people think they cover. Title policies have exceptions on them, and those are things that the title company does not cover. And so I'm going to step back just a little bit real quick on title insurance and coverage and talk a little bit about what it does cover. Title insurance does cover if there are undisclosed heirs, if you didn't know there was somebody who owned a piece of an interest in the property. It covers things like improper execution of documents in the chain of title. So if somebody didn't sign properly in the past or something wasn't properly conveyed, it covers things like forgery and fraud in the chain of title. And it covers unpaid taxes and assessments. So if there are liens on the property that were not known at the time of closing, if the title company didn't find them when they did their search and they're found out later, the title company covers things like that. There are a couple common endorsements. Those are additions to coverage, sort of like you might add additional coverage to your homeowner's policy or add additional coverage to your auto policy to cover different kinds of situations. The most common endorsement, which is an addition to coverage, is one that is for area and boundaries. And it provides coverage against discrepancies or encroachments, overlapping improvements, things that might overlap the boundaries of your property. And that there's an extra charge for that, and that can be added to the coverage. And usually the seller pays for the owner's title policy, and usually the buyer pays for the lender's title policy. And when you get a title insurance before you close and before that policy is enforced, you get what's called a title commitment. And the title commitment tells you what is accepted from coverage, and it lays out a whole lot of things that are helpful in your purchase. And there are a few different parts to the title commitment. The first part is Schedule A, And Schedule A talks about the details of the transaction. It talks about what type of interest you're going to be getting in the property to make sure you're getting a fee simple interest, which is the most common type of ownership in a property. It's what most people think they're getting when they're buying a property. And it shows who the owner of the policy is. And if there are additional people who are listed there on and in title documents, it lets you know that you may not have had a valid contract to begin with. You might have needed other people to sign on, or may need to get other people to agree to sell that property. The second part is Schedule B. And Schedule B lists the exceptions to the policy. And the exceptions are all the things the title company is not going to cover. And there are a number of standard exceptions. And those are, there's a number of standard exceptions, and there's generally just a handful of standard exceptions, and they're pretty common. Any encroachment or encumbrance that you would see on a survey. So important to get a survey or have a survey. Rights or claims of parties in possession. That's another standard exception. So you want to make sure nobody's living on the property that hasn't been disclosed. Construction and mechanics liens, those are a standard exception. If somebody started work and they have a right to get paid, those liens are valid if they've filed them. And taxes or assessments which are not shown in any public record. And so I talked about coverage a few minutes ago, taxes and liens. If it's a mistake and somebody didn't see them, but they were in the public record, those are covered, but if they've never been filed, they are accepted. And so Schedule B is the, Schedule B, though, is the most important, Schedule B is the most important piece that you want to be looking at. Because aside from those standard exceptions, which you'll see on all the title policies, there are other exceptions, and those are exceptions specific to your property. And an exception will not be covered in the title policy. And things you want to look for are access issues. Sometimes it will say it doesn't cover the access that you think you have to the property. It'll have the restrictions listed, and usually those restrictions are going to stay, but you want to pay special attention to those. We talked about development a few minutes ago. Those restrictions, it'll say where they're located in the public record and where you can find them. They'll usually attach them to the title commitment so you can read them. You can easily access them and read them. And it's important to check those out and to read them carefully and to know what you're allowed to do on that property, just like the question we just had about restrictions imposed by a prior owner. It'll let you know if the mineral rights have been severed from the property, which is very common in Texas. And it will talk about other types of restrictions. We have restrictions listed twice here, but there are different types of restrictions on property. And it will disclose easements across the property, and those easements can be anything from access easements, like if your neighbor has a right to drive across your property to get to theirs. It can cover in a certain area. Sometimes there's blanket easements, which are very interesting in rural property, meaning that somebody has a right, usually they're phrased to say someone has a right to any reasonable route over your property to get to theirs, or a reasonable route. And so those blanket easements are important to see and to have a look at and to see if they're still valid. And then any rights of first refusal. Sometimes in the records, there will be a right of first refusal, which means somebody had a right to purchase that property and needs to be notified before your purchase takes place. They may have a right to purchase the property. And then removal of exceptions. A lot of times what I do for buyers, I review title commitments quite often. And if there are items on the title commitment that shouldn't be there, such as easements that are no longer valid or have expired by their own terms, or that don't cover the property anymore, that are just attached because maybe this piece of property was part of a larger property in the past. You know, sometimes those need to be removed. So quite often I write letters to title companies, objection letters is what we call them, and go down the list of exceptions and do my best to get as many of those removed as possible so that the buyer is ending up with as much coverage as possible. And I want to point out here that the cost of title insurance, except for any additional items that you add on, any endorsements like we talked about before, except for those, the cost of title insurance is regulated in Texas, and everybody charges the same. And so your price is the same. We remove those exceptions or not, your price is the same. And so you want to get as much coverage as you can. You want to get as much coverage as you can for that title policy. And you know, like I said, the seller is usually paying for it, but you're usually paying for the lender policy if there is one. But you're getting that title insurance anyway. If you're getting it, you want to make sure that it is really valid. And one thing I want and really covers what you need it to cover. I've talked to buyers, not buyers, people who've already bought property who thought they owned a piece of property in fee simple that they had purchased from a neighbor. And you know, when he said, well, I have title insurance, and I said, well, I'd like to see that policy. And when I looked at the policy, there were so many exceptions on the policy and so many odd things with the property. One in particular that I'm thinking about was actually a condo unit that could not be sold in fee simple. It's still a condo unit. Even though the deed says he was buying in fee simple, the seller couldn't sell a fee simple interest. And the property, the ownership of the property is subject to a right of first refusal. Somebody else has a right to buy it before it was sold. It's subject to, you know, a number of things. And so it was as if that title policy, that insurance policy, if we think about a title policy the way we might think about life insurance, the title insurance that this particular person had was very much like having a life insurance policy that covers everything except accident and illness. And so, or death by accident or illness. So just about everything that the buyer would have liked to be covered or thought was covered was not. And the interest that the buyer thought he had, he did not have. And so I can't reiterate strongly enough how important it is to purchase title insurance and to review the title commitment. Sometimes when boundary disputes come up later, that title policy can protect you, and that title insurance is there to protect the interest that you believe you purchased in the property. And so a lot of times when there are problems down the line, the title insurance is where you can go to correct that, or where we direct people to or help them deal with their title insurance.
Hey, Joanne.
Yeah.
Before you move on, a couple of things, just a time check. It's 12:30. We're doing great. Two questions for you, though.
Sure.
One, the first one is, in your experience, how common or rare are, and I'm just going to spell it, ALTA, I don't know if we call it ALTA, but ALTA certified surveys required in rural property transactions, i.e. those primarily used for recreational and hunting ranches?
A lot of title insurance companies, they will have their own requirements. A lot of times they will accept old surveys that are not certified. It depends, I believe, on the title insurance company. They may ask you for a survey. I will have to check on that. My experience is that a number of different surveys have been accepted in transactions that I've worked on, but I would need to check on that.
Okay, so that may be
Yeah.
something we can follow up with. We'll have those questions. We can reach out to this person specifically if you find out some more information.
Yeah.
Another
Yep.
one is, when would an easement become invalid?
An easement can become invalid. Some easements say for so long as is necessary for access to the property. And
Mhm.
so, or for so long as is necessary for access to the property. So sometimes roads are constructed, in these old properties, sometimes there's easements that are 50 years old. And some of them say that the easement is valid for so long as is necessary for someone to access their property. And if there's a road on the other side, if there's a roadway now on the other side and someone has access, then that easement expires by its own terms. It's no longer valid. Or sometimes easements will have terms that say things like for so long as the property isn't subdivided into more than 2 parcels, because people don't want a lot of traffic down there across their property. And so an easement isn't always just a right of way that's there for anybody and anybody forever. There are a lot of times when we draft easements, there are limitations on who and how that easement can be used. And so, or to access, sometimes we put in things that say, to access up to 2 residential properties, 2 residential homes. And so if somebody develops and subdivides a property, they're going to need to find another roadway to use. So that's how an easement might expire by its
Okay,
own terms. Mhm.
great. We did get one more pop up before we move on. How
Sure.
important is the title insurance company's financial condition or rating?
So I have only dealt with um, most of the title companies I've dealt with are either large title companies or title companies who are agents for a larger company. So sometimes you go to a title company and you think, oh, it's just some little title company in the middle of,
Mhm.
some small county. But the company underwriting the policy, and you'll see it on the title commitment, a lot of times is a much larger
Mm.
company. And so those people doing, writing title insurance policies, that can be important, but I usually don't see it. What I see is smaller companies are larger companies are actually the ones underwriting it. So if you're dealing with one comes to mind, some little Main Street title in the middle of a small county somewhere. A lot of times it's a larger company underwriting that policy. And so I can't think of a time where I've seen a small company underwriting their own policies. And we can check into that further and answer that better. But yeah, that's what I see, is that those title companies are usually underwritten by larger insurance companies.
Sure. No, that's good for now. I think that's something, like you said, we can come back to if we need to. So basically,
Sure.
do your homework
Yeah.
and just invest a little time in research. Thanks, Joanne.
Right. And if you do get a title commitment back, you're not obligated to, that's one thing, you're not obligated to stay with that title company. So if you do get something back and you see it's not underwritten by a large company, or it seems odd, we can look into that, or you can look into it, but you're not obligated. Once a title company produces a commitment, you're not obligated to stay with them. So to close that out, the transaction with them, you can move. So, okay. Does that answer the question well enough for now? We can come back to it if we.
That's okay. Let's move on through, and I'll communicate with the attendee if we need to give some more information. Thanks.
Sure, great. And know the options you have for developing the property. We've talked about this a little bit in the beginning. You want to consider how you're going to use or develop the property. Do you want a bunch of houses? Are you going to do you want to keep it preserved? Do you want to, what do you want to do with the property? One house, no houses? Do you want to just use it for hunting? Are there deed restrictions? Is it in the city limits? And you want to look at county regulations. You also want to find out if there's a plat on the property already. Sometimes you'll find plats on larger parcels that you wouldn't expect. So you want to find out all of that. On maintaining an agricultural valuation, and one of the things we deal with a lot is agricultural valuations. And Mark, you can comment on that a little bit. But if a property has an agricultural valuation on it, you want to make sure, and you're not going to, and you want to keep that agricultural valuation, which lowers your taxes quite a bit. There are a number of things that need to stay in place. You need to keep that land principally devoted to agriculture. And one of the things you want to do before closing is to request the records of agricultural use from the seller. And it's good to do that in the contract to make sure you get those before closing, because you will have to apply in your own name for that agricultural valuation by April 30th of the following year, from the year that you close. And you will need to provide or list at least the agricultural use for the last 7 years. And one of the requirements is that that property have been used for at least 5 out of the last 7 years for agriculture. And you want to have whatever records the seller has to support that position.
Yeah, that's a great point you're making right there. Working with landowners all the time from my side, I hear that quite often where they say, well, I bought a piece of property and they said it was in ag, but there's no record of what they were doing. And so now I have no proof. So your recommendation of getting that in the contract, the requirements, that's a huge deal for a lot of folks. And that would save a lot of people a lot of heartburn because they would have that up front before they close. So good recommendation there.
Right. Thank you. And one of the things is those sellers are motivated before they close, and after they close, they're done.
Yes.
And you have to chase them down. And one thing I want to point out about ag is that there is no minimum acreage on the ag if there was no subdivision of the prior parcel and it was already under an agricultural valuation. And finally, the guidelines for intensity of use, meaning how many animals, if you're doing grazing, need to be on the land. Those vary a bit by county, and you want to be sure to follow the guidelines of the county, and Plateau can help you to do that. For developers, one of the main things here is just that developers should use a phase-in approach. They should know the minimum acreage requirements as far as wells and subdivision with the county, but they should also know the minimum acreage requirements for keeping an ag valuation, because we can subdivide and keep ag valuations in a number of ways. One of those is to allow grazing on your property. Another one of those ways is to create a wildlife management property association and support the wildlife in the area. And again, Plateau Land and Wildlife does that. The one thing I want to say about developers using a phase-in approach is that what is great to do is to subdivide, develop, sell one piece at a time so that you can keep the agricultural valuation and the lower taxes. If you buy a few thousand acres and you're subdividing this into, sometimes we see smaller, we don't work a lot on any of those. I don't know anyone in our office who works on those little postage stamp size developments, but a lot of the time we're seeing 5 acres, 10 acres, 12.5 or 13.5 acres if they're doing wildlife. But when those are subdivided, it's great for the developer to do this in a phase-in approach, develop a piece of it, and keep the rest very clearly in its agricultural use, and then develop the next piece of it and the next piece. And this is especially important if they're not going to keep the ag on the lots that they're developing. And you don't want to deal with rollback taxes. You want to deal with those as late as possible if they are going to hit. Rollback taxes are taxes on the prior years for the difference between what you paid and what you could have paid for the last few years when you change from agricultural use to any other type of use. And obtaining an agricultural valuation. If it doesn't have an agricultural valuation and you're buying a large piece of property, the savings can be immense. And the requirements to get an agricultural valuation are that, and this is a very shortened list here, but in general, the property must have been used for agriculture for 5 of the last 7 years. There's a number of ways to qualify. Some examples are cattle, keeping exotics for food or fiber, beekeeping, and you must apply to the appraisal district. A wildlife management valuation. If the property is already in ag, is already valued under an agricultural appraisal, you can transition to wildlife management, which is great because you can still get that value, that agricultural valuation on your property, but instead of having cows, cattle walking around, instead of your property being grazed, and instead of dealing with, herds of creatures, you can support the wildlife in the area. And you can either do that yourself, or you can do that by having a wildlife management property association with some of your neighbors. There are some limitations on size to do that, but there may be no limitation on size if it was an ag in the prior year and isn't being subdivided at the time. Is that right, Mark? Am I saying that correctly?
That's pretty much it. If it's a standalone ag property, and no matter the size, if it's a standalone 5-acre property that hasn't been subdivided or reduced, as you said, it can qualify for wildlife. And then it does vary by county. So we always recommend that if somebody's looking for land in multiple counties or owns land in multiple counties, that they get those specifics as well. And of course, we're happy to help them dive into that and make their life a lot easier too.
Yeah. And wildlife, people really like being in the wildlife. It's they're supporting the environment, they're supporting creatures in the environment. It's less intrusive than traditional ag. So we do that a lot, both Braun and Gresham and Plateau Land and Wildlife. Finally,
hey, Joanne, before you cover this last section, I think this is going back a little bit, but I think you can answer this relatively quick. If you do not get the mineral rights, so I'm assuming they bought a piece of land without mineral rights, right, can the person with the mineral rights access your property at any time to dig, drill, or extract any minerals or water?
Right. So that's a really good question, and it's an important question. The answer is it depends. And most of the time, if the mineral rights were severed a long time ago, many years ago, what you end up with is exactly that. Because in Texas, the mineral rights are superior to the surface, and so there are some limitations, and there are some ways that the courts protect landowners who have the surface, but they're minimal. For example, if someone can drill a well, wants to drill a well right where your house is located, and they could just as easily drill the well, 100 feet away or however far away, they need to do that. They need to not tear down your house and put the well on top of it if it could just as easily be done somewhere else. But those are minimal protections. And the newer leases, and it depends who did the lease as well, that because of fracking and because people can drill down and then the horizontal drilling, a lot of the time those those rights and the rights for someone to use the surface can be limited to a perimeter area or even outside the area of the land. But yes, it is a very serious concern if you are in an area where there is mineral oil production. So I see this a lot, minerals severed in Travis County, in Hayes County. It's so common. I'm sure it's under, they've been severed from almost every house that I've lived in Travis County. And but the likelihood of any digging for any oil wells going in either of those places is very, very, very small. Same with some of our other surrounding counties. And now a lot of times if it's in a county where there is mineral production, there are active wells, and there's a history of that. We like to make sure that we refer somebody to a landman to get a mineral remoteness letter, a letter that says what the likelihood is of there being drilling in their area and what that might look like. And so, yeah, if absolutely, if the mineral rights have been severed, you're in an area where there's oil production, you want to consider that there could be wells on your land, including roads and infrastructure that they need. And I'll tell you, we have people who buy land all the time where the mineral rights have been severed and they're in areas where there are wells, and wells need to be a certain amount of space apart. But people sometimes buy a few hundred acres for hunting, and they don't care that there's 2 wells on there and going to be 2 wells running on there. They're out there hunting, they stay away from the wells, especially in more areas where you don't see those wells from across the property when they're more wooded but we do have people who make that decision. They can get a hunting property a little cheaper if there's wells on the property. But yeah, that is a consideration. And I will say that one of the places people can go to have a look to see what's going on is the Railroad Commission. And the Railroad Commission is who regulates I know it's funny, but the Railroad Commission regulates oil wells in Texas. And you can go to the Railroad Commission website and you can see where the active wells are and what's going on in your county and your area pretty easily. So that's a good resource for people looking to buy rural land.
Okay. Hey, thank you, Joanne. And I was going to let everybody know we're going to go ahead and keep going with because we've got another question. This is a great session for those of you that are listening in. It's all going to be recorded just in case somebody needs to jump off. We're going to send you a link to all this that we're doing, so you won't miss anything in case you have to go. But Joanne, I think it's like a follow-up question to your well question. Can not having mineral rights cause issues when or if you dig a deep water well for water on your property? So if you don't have the mineral rights, can there be issues if you want to dig a water well?
I'm not an expert on where water, where the water table is compared to where oil is in the ground, but
Gotcha.
In general, I believe they're digging a whole heck of a lot deeper to get to oil than they are to water. And there are when you're near an aquifer, over an aquifer, a lot of times there are limitations on what can be done by oil, to extract oil and things. You can't usually there's caution about the aquifer, but yeah, I don't think that's an issue, but it's something we would want to come back to. I have never had that be an issue. I know we have clients who own land where there are active oil wells and they have water wells on their land. And this is not an answer coming from somebody would need to verify this, but my understanding is that how deep people are drilling for oil is just a heck of a lot deeper than they're drilling to get to a water table.
Sure.
So yeah.
And that makes sense. Yeah, that makes great sense, Jan. I think one thing I want to let the attendees know it sounds like we're getting into some very specific issues. Joanne's going to have the opportunity to reach out to you. You're going to have both of our contact information. So I would love to continue this conversation. Please keep asking the questions. We're going to keep rolling on through this, and feel free to keep typing away, guys. It's good stuff.
Great. I'm going to get to this one last thing, considering how to protect your assets, and kind of just to recap. If you are one of those people who it's best that your the use of your land justifies creating an entity and putting that land inside an entity such as an LLC, which we kind of prefer, but partnerships, LLCs, we do a number of things. But one of the important things about when you put your property inside of an entity is that you follow corporate formalities. And by that, I mean that you keep what is going on with that entity that we've created to hold your land, is that you have your regular meetings, you have your yearly update, whatever is required. LLCs have a very low bar on what's required, but that you keep the money separate if there are things that are expenses of the entity holding the land, and that you do follow the requirements that are in the business organizations code for what you do to maintain an entity. And the reason for that is, if you are ever sued, especially if it's a single member LLC, you want to make sure in Texas that you're showing that there really is an entity separate from you individually, because they call that piercing the corporate veil. It's not really an entity. There's nothing they did. They just made this name and threw it in there. You want to have those formalities kept in order. You want to keep your business stuff separate from your personal. It helps more than just with taxes or other types of things. It is important as far as liability. Homestead protection. I want to make the point that there's different kinds of homestead protection in Texas and homestead rights. And one of the things that people think about a lot when they think about their homestead is that the limitation on their property tax when they claim their homestead for property tax purposes, that homestead exemption. And then there's a different kind of homestead protection. It's statutory homestead protection against creditors. And in Texas, those two do not need to be the same property. And so one of the things that people can do if they own a large piece of property is that they can claim as their statutory homestead protection against creditors their large piece of up to, I believe it's 200 acres in Texas, that they can protect from creditors, from collection, from being repossessed by almost anybody except the IRS. But they can protect their property. And sometimes when that rural property is the most high dollar piece of property that you own, if some people have a city home and then they have a ranch, if your rural property is where most of the value is, or has more value than your personal home, it's beneficial to fill out a form, turn it in. We can help you do that. We file it in the county records, and it claims your rural property as your statutory homestead, which is protected from creditors. Now you have to choose. You don't get it both places, but if your land is where most of the value is, sometimes it's beneficial to do that. And like I said, it does not need to be the same homestead that you are getting your homestead exemption on for property tax. And finally, insurance. There are some requirements under the property code. There's a recreational land use statute that protects recreational land owners from liability, but you need to do the things listed in the statute, and one of those is to carry a certain amount of insurance. And if you carry that amount of insurance and you follow the other rules under the statute, then your liability can be limited so that you are not, if there's an accident on your land, that there's not a judgment against you for $10 million, that bankrupts you. So it is important to follow those kinds of requirements, to look at that recreational land use statute, to make sure you have enough insurance, that you have done the things in the statute. The main one that comes to my mind is keeping that minimum amount of insurance coverage in case there's an accident on your property. It's really important beyond just the amount that the insurance might cover. And that's about it. As far as protecting assets, I think that's
Hey, before you leave that slide, Joanne, can you go back real quick?
yes.
As a landowner myself, my family has about 126 acres in Mason County.
Mhm.
What I was curious about is that first portion about creating the entity. Currently, my mother and my aunt own that, and it's split just in half between the two because my uncle and father are gone.
Sure.
They own it in their personal names, and I manage the property as one ranch just because that's how we work it. Is that a situation, and again, we may not have time to go that deep, but is that a situation as a landowner that I need to be thinking about that, or is it okay to leave it in their personal names?
Right. Do they live out there?
They do not.
Okay. And so there are a couple factors there. Is the property used for hunting? Is it used for things that might cause liability?
Yes. So for the most part, it's a completely recreational property. I put it in wildlife management because I used to work for Plateau. Got to do that.
Yes.
But yes, it's mostly recreational, with some weekends being spent hunting, no recreational vehicles, stuff like that. But we do quite a bit of recreational activity, mainly hunting.
Right. Probably what would be beneficial, depending on the extent of what's going on out there, is to look at the insurance, to look at the recreational land use statute, make sure there's that amount of insurance on the property, because then you're protected if something happens. So in that situation, we would need to look at the details to give you a solid answer. Okay. But my initial feeling is that if you look at the recreational land use statute, you follow the guidelines in that statute, and you make sure you have the minimum amount of coverage, insurance coverage required, that may be enough. And for situations like that, a lot of times that is enough. And one of the other reasons people sometimes want to hold property in an entity is for anonymity. We do a little bit of that, and you can't get complete anonymity, but there's some barrier that can be made there. But back to your question, yeah, probably your situation would be a situation of insurance and making sure you follow the requirements under that recreational land use statute, which is meant to protect landowners such as your family from an accident or a liability taking that land away. So
okay.
Yeah.
That's great, because I do know we have insurance, but you're bringing up a question. I don't know if my aunt has insurance on her side of it. So now I need to make sure that my mother and my aunt are actually having some insurance.
Right,
provided.
And that you have the minimum amount listed under that statute. And so, okay. And there are some other things in the statute too, and some other guidelines that we talk about in a different webinar that are helpful to help prevent liability for anything that happens on the land. So
great. And I think my point out of that conversation is almost every landowner needs to look into some of this minimum protection for them, not just the big guys, not with the big ranches, just everyone that owns a little property probably needs to look into this.
Right, because no matter what people do, no matter what you do no matter what precautions you take, no matter what you do, every once in a while, something can happen that was unexpected or terrible. And, you want to not only have insurance to help cover whoever's injured or whatever might happen, but also to follow those statutory guidelines so that you don't lose your land if something were to happen.
Absolutely. And I know we're ending or getting close to end time, but we've got another question. I think it's a great one because it's a clarifying question.
Sure.
The attendee asked, can you explain the recreational land use statute for the insurance again?
Sure. The recreational land use statute is a statute that was, are they asking about the amount, or are they asking about,
that was the only, and then they may type in something here in a minute, but it was, can you explain the recreational land use statute for the insurance? And it just said again. So whatever you did, it must have been okay. They just wanted maybe to reiterate.
Yeah. And so I don't have all the details off the top of my head right now. But I will say this. The recreational land use statute is something that was created by the Texas legislature to protect landowners from liability for accidents, particularly in many common recreational uses. But you want to take, you want to make sure I think, I don't want to say a number out loud because I don't want to give you the wrong number, but there is an amount of insurance that is required under that statute that people should have. And there are some other things that they can do to, to limit liability under the statute. But yeah, you need a minimum. What happens is the statute only helps you if you have the minimum amount of insurance coverage. You're only limited to your, the statute requires people to have insurance to help people who might be injured. And and if you do that, then the legislature has said that there's a limit on how much you can be sued for. And so that's the deal. If you have no insurance and you don't have the minimum amount of insurance, then that statute doesn't help you. And so that's the deal. And it's like I said, I don't have the number in front of me right now. I'm pretty sure I know what it is, but I don't want to put it out there for people to have the wrong information. Yeah.
That's okay. We can do a follow-up with that one.
Yes,
there was a follow-up question. There was a follow-up question. How is it different than regular insurance?
How is what different than regular insurance? Having insurance under the statute here?
I think that's what they're saying. So if I've just got regular, I'm going to paraphrase. I don't want to put words, but I'm assuming like I've got liability insurance on the ranch for protection. Yep. Is this a different animal?
No, it's liability insurance for accident, just like you would purchase, just like you would go out and buy insurance. It's the same thing. It's just a minimum amount. You need a minimum amount to protect people from accidents on your property. And so it's not some special call your agent, I need this kind, but it must be liability insurance and it must cover accidents on your property. But that is something that is common, and it's not some special, it's not something with some special name to meet this requirement.
Okay, so I think you answered it. So it's still liability insurance, but you need a certain amount for that to meet the recreational land statute requirement.
Yes, you can't have, right? And it's not some low amount. It's not like you can have, $20,000 of insurance and you're okay. You need to have enough to cover accidents, and there's a number, there's a statutory number, and I don't see it in front of me right now, but we can look that up.
We'll get that. Yep, we'll get that, and you can even put that in your, if we, or you or I can put it in our follow-up email.
Yes, we sure can. Is there anything else, Mark?
Right now, no. Is that the end of your slide?
Yep, I think that's the, let me see what we have here. Here we go. This is to talk about the landowner. You want to talk about the landowner alert system?
Well, you've been talking a lot, so that's fine. So guys, if y'all want to keep up and stay abreast of any changes, the latest and greatest, this is a wonderful way to do it. Sign up for the newsletter. You'll receive some updates if there's changes, if there's new law, whatever it is. This is a great way to do it. So please don't hesitate to sign up for that newsletter. And then Joanne, I think we got one more.
I think, yeah. And I'll say, I think the minimum, I think the minimum coverage is, I think it's $500,000 for each person and $1 million for each single occurrence of bodily injury or death. So it's a good amount of coverage.
Thank you. All right. And then I think you have one more slide, maybe with our contact information.
Sure. Questions? We've had questions. And
Yeah,
and there you go. Here we go. Here's our contact information. And feel free to contact me or Mark if you need anything. And we're glad you've been able to join us today.
absolutely. Any other questions before we sign off? Thank you all so much for hanging in there. There's a lot of good information being exchanged. And again, do not hesitate to reach directly to Joanne. If you're not quite ready to speak to an attorney, I'm the landowner advisor. We can just have a good old discussion, and then I'll bring Joanne or whoever else we may need to bring into the conversation. So Joanne, thank you.
Thank you.
Wonderful presentation, and thank you guys for joining us.
Thank you very much.